Welcome to the Real Estate Life Podcast. So on this podcast, we are dedicated to creating a life of passive income through real estate and doing something that we love along the way. So today we have a special guest, Adrián Acosta. He is the attorney that specializes in evictions and family law. He is also a good friend and is counsel to SAR Apartment Capital and has advised me throughout this COVID process, which we needed a lot of help on. And I think all of us that are landlords are also going through the same experience. When it comes to this ever-changing dynamics of landlord and tenants law in Miami-Dade and Broward County, he is the man that I go to. Adrian, how you doing today?
Pretty good, Abiel. Thanks for having me on.
All right, brother. So Adrian, just so the listeners could have a little bit of background, tell us a little bit about yourself and we'll take it from there.
Well, I was a paralegal for 11 years for a civil litigation firm. I went off to law school in 2013. I graduated from St. Thomas School of Law in 2016, took the bar in 2016, got licensed in 2016. And then I went out on my own in February of 2017 to open up my current practice. I've been an attorney for almost 5 years now. I specialize primarily in the realm of family law, criminal defense, and thanks to you're doing landlord-tenant law.
So the way this took off, there was a deal that we bought a couple of years ago. I bought 102 units in Miami in a neighborhood called Little Havana. It wasn't a distressed property, but it was definitely a property with tenants that were paying very old rents. It was probably like 12, 13-year leases. There was a lot of month-to-months. So throughout the process, when we started executing our value add and increasing rents, I needed a lot of help from legal counsel on how to proceed on 15, 30-day notices, evictions, and so on and so on. Reached out to Adrian, and I think that took a natural course. Adrian took the challenge and educated himself very quickly on eviction and laws related to this. That was quite an experience for us. Things have changed since then, and I would say that now we have different challenges. And today's show it's about what's going on with COVID, CDC, moratorium laws, and I want to jump straight into it, Adrian. So CDC has issued a moratorium on evictions that's halted evictions to January 31st. There are rumors, and there's a good chance that this could be extended, but as of now, let's talk about what's going on and what are the 5 criteria that landlords need to know about evictions. They're pretty long, so let's just summarize the 5 so listeners can get an idea of what they are.
I mean, basically in summation, you have to show that you have some sort of an economic hardship. You make less than approximately $99,000 and that you've tried to seek some sort of governmental assistance. The CDC basically created like this declaration where the tenants just basically fill it out and they submit it to the court. All that does is prevents the sheriff from executing on the writs on the back end, right? Regardless of the fact that there's a CDC moratorium, you still have the opportunity to file a complaint for eviction, whether it's for non-payment of rent or to terminate a month-to-month tenancy. So what I'm seeing now is a lot of landlords are waiting for the moratorium of their evictions to be lifted to then to proceed with filing a complaint for eviction. That is not the way really to go about it, because you still need to hire an attorney to do the legal part of it first before the actual executing on the writ and tendering possession back to the landlord occurs.
So you're saying that some landlords are strategizing and say we're just not going to start the process because we'll just wait until the 31st comes up, and so that is not the right strategy.
That's not the right strategy. What you need to do is obviously initiate obviously get your 3-day or 15-day notice. The 3-day would be for non-payment of rent, or a 15-day notice would be pursuant to Florida statute to terminate a month-to-month tenancy, meaning a tenant who's not under a lease, correct? So you need to comply with those provisions before initiating a complaint. You initiate your complaint, you serve it, the defendant has 5 days to respond. Depending on the response, depending on how quick the eviction moves, if they file an answer, you have to either move to strike their answer. If they don't do anything, then you can default them. So after the complaint is filed and after they've received service, it can go a myriad of ways, right? Hence the reason why you should file now, because at the end of the day, the moratorium doesn't stop you from obtaining a final judgment. The moratorium stops the sheriff from removing the tenants and then tendering the possession over to the landlord, right? It's kind of
Now,
like this.
yeah, so let's touch base on that because I know that I've asked you this question a few times, and I think I've even called you on a Sunday to ask you this question. Are the sheriffs showing up? Are they open right now in Miami-Dade or Broward County?
Absolutely not, which goes back to my prior point on why you need to file an eviction as soon as possible. The sheriff, especially in Miami-Dade County, they're putting them on a queue, on a list, right? So as the final judgments get rendered and as they receive what's called the writs of possession, which is the clerk advising the sheriff to tender possession over to the plaintiff landlord, they're putting them on a list. And when they start executing on these, they're going to go through the list in the order of which they were submitted. So if you wait to the last minute, you're going to be way down on the list.
So let's talk about that list because we looked at some interesting stats right before we got on this podcast. How many evictions are they tracking in Miami-Dade and Broward County? So people can have a perspective of how important it is to start filing.
Well, as of December of 2020, there are 7,000 active evictions in Dade and Broward County combined.
So that's insane. So that's how full this pipeline is going to be, guys. If you gotta start following your process. I mean, hopefully it doesn't get to that, but those numbers are scary. And from what I've seen, that there's a good chance that this stuff could double. And I wouldn't be surprised if it does. Very sad, but this is really happening. Yeah. So that's our advice. Start the process. Don't wait. If you could communicate with your tenants and find other process, just try to do that. Okay. So what one of the things that's happening to me is I do have tenants that they do meet the CDC criteria. They're following the steps. They're providing the paperwork. They're working with our management company. And those tenants, I do appreciate that they work with us. We've had a lot of tenants that receive government help. We've gotten checks. It's helped us as a business to be able to maintain our properties and continue to give them, a nice, clean place to live. And that's the part that sometimes tenants and landlords tend to forget. It's an operation, it's a business. It costs money to maintain these properties. But there is that. And I won't say it's a very, very small amount. It's very surprising, things that, oh no, all tenants are not paying. No, that's not true. People do want to pay rent. People do want a place to live. They don't want to go through this. They don't want their landlords asking them, when you're going to pay the rent. Most people do not want that. So what I've seen is there's a very small percentage that just don't care. They are not caring to follow any of the CDC guidelines. They're not filling any of the paperwork. They're not cooperating with the management. Now, what do we do about those tenants, those problematic tenants that are disrupting the apartment or the place where they live, making it difficult for other tenants to live? What about those, Adrian? Is there any way around that on the ones that are just very problematic?
Unfortunately, it depends, and I say it depends because it depends on the tenant's action, right? Is he unruly? Is it getting to the point where the tenant's being violent and then police have to be called? Then there's probable cause that this person's committing a criminal act. That there's that extreme, and then there's the extreme that the tenant is taking advantage of the landlord. The tenant knows that there's a moratorium on eviction. The tenant hasn't made any single bit of effort to seek any sort of governmental assistance to help out with the rents, and they're just sitting there not paying rents, and there's nothing that the landlords can do because the sheriff's not executing the writs of possession and not tendering possession over to the landlord based on the CDC moratorium. So we're in a really weird place, and I'm having that. In the beginning of the pandemic, we all assumed, hey, this is going to be 2 weeks, right? 2 weeks went into months, and now we're almost about to be a year in March. I've been encountering a problem where my clients have said, yeah, I just want to get possession. Let's focus on that. I get possession early on in 2020, let's say April, May, or June. I only have a final judgment for possession. I don't have money damages. And now here we are months later with months of rent not being paid to the landlord. And now the landlord, who is my client, is asking me, now I want to go after money damages. Now I want to do this. And sometimes what you need to understand is money damages, we have to take extra steps, right? I have to personally serve the tenant with the copy of the complaint, right? Which is called in personam. It's like a first-year law school thing. In order to get money damages against somebody, that have to be personally served. In rem, which means of the property, I just have to post the summons. My process server has to post a summons on the door, and that allows me to get possession, not money damages. So I was proceeding under just posting them on the door. That's 5 days notice, get the final judgment, get possession. But I don't have a money judgment. Now, here we are. Now I'm in this difficult situation where the landlords are out several months of rent, tenants still on the property. I've had the final judgment for several months. And now I would have to either A, file a separate action for damages, or B, amend the current complaint and try to seek money damages and then personally serve them, which sometimes the tenant's vacated, they don't leave a new address, I don't know where to find them, and that just leads to a whole other myriad of problems down the line.
Yeah. So let's talk about leases expiring or month-to-month leases, especially when the landlord just wants to get possession of their property. There's no the tenant's not defaulting; they're making their payments. But still, you know what? The landlord, the owner, wants to get possession of the property.
Right.
Same scenario. Is it going to fall? There's no way of enforcing this either. It falls right back into that.
If you're speaking about leases, now we're talking about, it's kind of like in the realm of contract law, right? So I can't really, if there's an active lease, let's say for another 6 months, I can't really terminate that month-to-month tenancy unless they breach one of the provisions of the lease, which is typically non-payment of rent, or destruction to the property, or interrupting quiet use and enjoyment with the neighbors, things of that nature.
I'm talking about leases expired. It's already going month to month. You want possession back of your property. They were paying tenants, but you just want your property back. You give them a 15 or 30-day notice, depending on your state laws. You're still at the mercy of the tenant saying, you know what, I don't want to move out. I want to continue paying. Do you keep accepting their money? So let's say I'm going to walk you through a scenario, and this is a scenario I've been through. The lease expired. Tenant was a paying tenant, but I want possession of the property. So I gave the tenant a 30-day notice that when their lease expired, I wanted possession of the property. The tenant ignored it. He goes, no, I don't want to move out. I'll continue paying you. So the tenant goes and continues depositing their money. Should I return their money back since I want possession of the property, or should I keep it and keep enforcing it? What should a landlord do?
So I think you're confusing two concepts, right? Which is non-payment of rent and terminating the month-to-month tenancy.
Terminating. We're talking about terminating.
So the lease is expired. They're a holdover tenant. It's month to month. You just give them the notice. You can still accept rent because you're not complaining about the rent. You're complaining about him not being the tenant not tendering possession over to you after you've given them proper notice, right? So you can still proceed.
Mm-hmm.
You can still accept rents.
Okay.
Just need to realize that, which is a lot of things that landlords forget about, is remember, especially in Florida, you have about 50. Once a tenant vacates and you have their deposit, you have 15 days to write to that tenant and explain to them, either return their deposit if the tenant is a unit is in decent condition, or return a portion of the deposit and explain why you are returning a portion of the deposit. Usually you support it by estimates if there's damage on the property or something that wasn't taken care of. And that's not just typical normal wear and tear,
Okay.
right?
All right. So your suggestion is continue taking the rent payment instead of instead of not taking the payment and saying, I would like for you to move out. I will not accept your payment, because by accepting the payment, it will continue our month-to-month process.
No, because you can't accept payment on evictions that you file for non-payment of rent.
Okay, we're talking about paying tenant that the lease ends.
Right, but you still want them out.
So
you're terminating their month-to-month tenancy. They're still obligated to pay rent during that tenancy. That tenancy, you know.
Got it.
So don't confuse non-payment of rent and terminating a month-to-month tenancy. They're two different things. In non-payment of rents, you're not allowed to accept partial payments or any rents.
All right. So let's go. Let's go to a tough question. What was the most difficult eviction you have had, and give us how you fixed that. And the reason why I want you to give us the worst case scenarios, because I feel like every landlord at some point might go through this.
Well, I just lost my first eviction, and it wasn't my doing. And this is some tips that I would explain to landlords to make sure that they have all of their ducks in a row. Certain landlords, what they like to do is have a move-in date that's not on the 1st. And then let's say the tenant wants to move on the 5th, you have to prorate a daily rate for the amount of rents for the days in that month that they're occupying. It's really easy sometimes to screw up on that calculation. And it comes down to the line that the tenant doesn't pay the rent. And then the landlord does a 3-day notice, and that 3-day notice is off due to them not properly prorating the rent. You basically lose automatically, because that means your 3-day notice was defective from its inception, and then you have to follow a new case. So that's one lesson I learned. So I don't recommend any landlords to
how
have
much time.
dates.
How much time would you lose on making a mistake like that, just so they can have an idea how something so simple like that could make them lose time?
Oh, well, on this one, due to the pandemic, I think the client's out $8,000.
How much time from now for him to correct that would he lose? How many weeks not to resubmit?
Oh, they have to they have to correct their ledger, create a new 3-day notice, put the new 3-day notice, let the 3 days run, then depending on your attorney, if they're able to do the complaint the same day, file a complaint, wait for the clerk to generate the case number, which can happen the same day or the next day, then issue the summons, then have your process server go out there and serve it. Once it's served, then they have 5 days to respond. And then you're running into, you don't know if they're gonna file a response, they're gonna just sit on their back, and then you default them.
Yeah, something so simple.
Something so simple can get really complicated and then eat up several months.
Yeah. Now, I want to jump to the next topic. Me personally, I've never done this. It was very interesting for me to hear that you're handling something like that. Landlords financing deposits and moving costs to their tenants. Why this is a bad idea? We're not saying that you should not do it, but let us know why this could be a bad idea.
It's just hard to explain to the court why you got to that number. So then I have to pull in a witness who's typically like my client's bookkeeper. I got to pull it in. I have to explain to them why we got to these numbers. Like, why is the rent so much higher every month when the rent amount is a certain amount, right? You have to explain to them they're financing either first, last, or security, and that they had like whatever 6 months to get caught up, and then the rent went back, and it just creates more confusion and more it gives the defense more of a way to get out or prevailing with the eviction against the landlord, and then the landlord having to start over again. So that's just something based on my personal experience with one of the cases I had. Like, if the tenant doesn't give you the first, last, and security up front, you typically don't want to finance any part of any security deposit or first or last month's rent.
Yeah. All right. So what's your biggest failures that you had in practicing law and practicing evictions? I could tell you my biggest failures with tenants. One, we've mentioned them, not serving correct notices. Another one is not taking a picture when I serve that notice on the door. That one is that you have to implement that. There's so many of them. Give us some of yours.
I mean, obviously, like making sure that the numbers that you put are correct and accurate. Keep a detailed accounting, keep a detailed ledger. I know some of my landlords, they just have an extra rental property and they don't really do that. But and I can show it through other ways, through bank statements or something to that effect. But just keep a good record of the amounts of rents that are coming in. Remember that even when a tenant vacates, you should still let the tenant know why you're keeping their deposit, whether it's for back rent or whatever, because then you can be exposed to attorney's fees and having to return the deposit if you don't follow some simple steps by writing them a letter as to why you're keeping them the rent after they vacate the premises. Making my personal opinion, like experience, is being clear with what your client's wishes are, whether they want money damages, whether they want possession.
That's something that could change along the way, because I could tell you I've felt that way in the past, where I'm okay with the eviction, and then I find out what the tenant did to the property because I didn't get access to the unit. So that's something that could change. And I've been in that place where I'm like, okay, I just want to do the eviction. I know the property's not in good condition, but then when I actually get the eviction done and I see what's inside, it's upsetting sometimes. How would you suggest how do they go about that?
Well, as far as like damage to the property,
Correct.
I mean, then you would file a separate lawsuit for damages, right? That's if in a perfect world, which typically doesn't happen in a lot of our situations, the tenant vacates and then they give you an actual address, or an email or something where they're going to be, right? That typically never happens in our situation. The tenants vacate, they're gone. We don't know where they moved out to, and then you get possession of the unit. They didn't do a walkthrough, and the place is destroyed, right? And now we're not talking normal wear and tear. I've had some instances where the tenants vacated and all of a sudden the unit mysteriously catches on fire. I've had a nightmare where a tenant has poured concrete down the drains and then screwed up all the plumbing. I mean, I've seen it all. And these are things that I, as a lawyer, can't control. And, if these people vacate and they don't leave an address, now I got to, hire a private investigator.
Have you seen these things settle? Have you seen any of them settle?
As far as like damages?
Correct. Never.
Never.
Yeah, it's
They're
tough.
gone.
I don't
know where they're at.
It's tough. It's too expensive to chase them.
And then you gotta, you as a landlord have to do a cost benefit analysis. Like, am I gonna pay an attorney X amount of dollars to then maybe or maybe not get a money judgment against the prior tenant? Does the prior tenant have any assets? Like, what, is he collectible on a judgment? So that's where your cost benefit analysis lies.
I always advise, and if it's possible, if you could do it, I always advise my partners or friends and family who are landlords, your first step when dealing with a difficult tenant should be a cash for key. I know it's hard. Some people are like, I don't want to give them money to move out, especially right now during COVID. Cash for key for me has been a savior, where I just offer the tenants money to move out. I offer their first and last month to move out, or I even offer them moving help. I'll get a moving company to help them. That's a strategy that I learned years ago through REOs and buying foreclosure properties. But that strategy helps. Now, it doesn't always work because in reality, some people do have difficulty finding another place. But always go to that first. Adrian, so how can listeners reach out to you?
Well, you can go to my website, which is www.adrianacosta.com. All my information is there. You can give me a call. I'll respond. My goal is to respond within 24 hours, especially now with all the high volume I've been dealing with evictions. but my goal is to always respond within 24 hours. I'm here to help. If I'm able to assist somebody and just guide them, I'll be more than glad to. But typically, it's better off just going with an attorney and not dealing with it, because especially in situations where these properties are owned under corporations, which I wanted to mention earlier, corporations always need to be represented by counsel. So that is the easiest way for a judge to either dismiss the case or delay the case, because the corporations are trying to do it themselves, and corporate entities can't represent themselves pro se. So
okay, that's good to know. See, I didn't know that one.
Important for them to know.
Yeah, that's good to know. Adrian, thank you for your time. Till next time, brother. Take care. Bye-bye.